table.
Yes.
My Lord Justice Arnold raised with me directly a question in relation to a statement, as to whether or not a statement has been taken by my client from Mr. Mervyn. And I assume your Lordship's question stems from paragraph 28 of the judgment, in which the Deputy Judge says, page 172, it appears that JNFX took a statement from Mr. Mervyn. That assumption that there was such a statement appears to stem from a WhatsApp message sent by Mr. Mervyn to Mr. Giwa, and that WhatsApp message is to be found in the second volume of the supplementary bundle at page 504, which I'd invite your Lordship to look at very briefly. Exchange at the bottom of the page on the 19th of November 2021, where one sees at 10, 11, 16, so 7 lines up from the bottom, one sees there Mr. Mervyn saying hence why they took a statement from me. Obviously these are WhatsApp messages which are not within the knowledge of JNFX, and I can only look at them as they're stated. There appears to be an exchange with Mr. Giwa in relation to the monies, presumably with respect to the 10th contract having been held up. There's a reference to line 100919 to SARS, which one presumes is a suspicious activity report. But in any event, one does see there Mr. Mervyn saying, the issues I've done, JN, meaning JNFX, would have had to protect themselves by reporting my activities as suspicious of anything I've touched, or they'll be condoning it, hence why they took a statement from me. It is from there and there alone that the judge appears to have accepted that a statement was taken from Mr. Mervyn by JNFX. I've taken instructions from the directors of JNFX who were in court this morning, and I've obviously heard the Lordship's question. And whilst I appreciate it's not in evidence, and I can undertake to provide a witness statement from the directors confirming that's the position, my instructions are that no statement has ever been taken from Mr. Mervyn. There is no such statement, so no such statement has been disclosed. Can I move then swiftly, I'm mindful of the time, to ground 3, which is the reliance point. In our submission, the judge erred in finding that JNFX had no realistic prospect of showing that the representations were not relied upon, or reasonable grounds existed for believing a fuller investigation would alter the evidence available. Paragraph 27 of the judgment, the Deputy Judge finds in the last sentence that it defies common sense to suggest that Mr. Giwa entered into the multi-choice contracts other than on the basis of the representations. I've already addressed your Lordship's in part on this, but there are just 3 short points I'd make here. Firstly, in respect of the use representation, we submit the judge was wrong to reach that conclusion for all the reasons we've already advanced under the heading of ground 1. As to...
Well, I don't understand that. Obviously, if the representation was never made,
yes,
the issue of reliance doesn't arise. And your ground 1 goes to that question.
yes.
So we only get to this if you've already lost on ground 1 and we're satisfied that the use representation was made.
Yes.
In which case, ground 1 has already failed.
But the evidence that we rely upon under the heading of ground 1 to demonstrate that the use representation wasn't made goes to Mr. Giwa's knowledge and understanding of what was happening in relation to the operation of the alleged contractual arrangements. So I've taken your lordship's evidence in Mr. Giwa's reconciliation narrative, where he plainly understood at the time, and in our submission therefore accepted, that what was not happening was the specific use of designated monies in relation to the transactions. So Mr. Giwa was well aware that even if that use representation had been made, it wasn't being complied with. And so in our submission, one can't say it defies common sense that he didn't rely upon it. He can't have relied upon it because he knew that wasn't happening. But the point goes no further than that. And in relation to reliance on both representations, and again, in a sense, this is perhaps repeating the points that have already been made, but we've drawn the court's attention to the evidence of Mr. Giwa on his own case, that where Mr. Mervyn was unable to source the relevant monies, what was happening was that refunds were being made. So it is difficult in our submission to say that it defies common sense that Mr. Giwa must have relied on a representation that all of the monies would be paid. But again, I suspect your lordship will make the point back to me, but that in a sense that goes back to the points I've already made in relation to falsity. And I don't propose to address your lordships any further in relation to reliance any more than I already have done this morning. I want to move to ground 4, which is the issue of ostensible authority. On this issue, the judge found paragraphs 29 through to 38 that JNFX had no realistic prospect of showing that Mr. Mervyn did not have ostensible authority to act on behalf of JNFX in entering into any contracts, and that there was no reason, or that there were no reasonable grounds to think that a fuller investigation on the facts might alter the evidence available to the trial judge. And in our submission, the judge's findings on this issue over the course of that paragraph plainly were an impermissible trial on the evidence. So we obviously make the point in our submission that it failed to take into account all the evidence that might reasonably be expected to be available at the trial, not least because that trial on the contractual claims would happen further down the line following disclosure and so forth. More significantly, given that the basis of the respondent's case is that the relevant contracts were all largely entered into and varied orally, and as I made clear this morning, there is no clean suite of documents evidencing their terms. In our submission, this was the type of issue which plainly ought to be resolved at trial after hearing all of that relevant oral evidence. And in particular, whilst Mr. Giwa placed reliance on a number of matters to advance the proposition that Mr. Mervyn had ostensible authority, in line with Lord Hope's judgment in the Three Rivers case, which I took your lordships to this morning, it could not be said by Mr. Giwa that all of the evidence pointed only one way. In that respect, it was and is not in dispute that many of the emails sent by Mr. Mervyn on his JNFX email address contained the footer which is recited in paragraph 9 of our skeleton argument.
Yes, can you show us at least one example in
yes,
context?
Of course. If one goes to the it's in the supplementary bundle. It's volume 2. It's page 349. This is just taking one of the emails, so it's an email on JNFX email address, and one sees the sort of signature block at the bottom, and then the footer is there at the bottom.
So, just remind me, what's the wording that's relied upon in that block of text, which is quite faint for those of us whose eyes are less good?
Yes, no, I'm sorry, and forgive us, we haven't sought to produce a whole load of supplementary documents and circumstances where the fact that that footer is on in many of the emails is not in dispute. So
Well, indeed.
I appreciate
There's a difference between that fact not being in dispute and understanding what the impact on the reader is supposed to be. So if you could just remind me, what's the text
yes,
that we're relying on?
Of course. So starting from the fourth line down, towards the right-hand side, where it says JNFX Ltd makes no warranty or representation as to the accuracy or completeness of the information, does not assume whatever commitment hereby. Materials by a representative of JNFX Ltd is for information purposes only for market counterparties or intermediate customers, and should not be construed as a solicitation or offer to buy or sell any financial related products. Legally binding obligation can only arise for or be entered into on behalf of JNFX Ltd by means of a written instrument signed by a duly authorised representative. JNFX Ltd excludes any liability whatsoever for any direct or consequential loss arising from the use or reliance on this email or its content.
Does written instrument signed by a duly authorised representative include emails sent by a representative?
In our submission, no. JNFX's position that what that envisages is a contractual document, for want of a better expression, an instrument in itself. There may well be an argument about that.
Well, can you just help me? Let's take this email by way of example. Would you dispute that it's in writing?
No, it's...
Right, so it's in writing.
Yes.
Would you dispute that it's an instrument?
Well, we would say there's an issue of construction in relation to what's meant by instrument.
Well, how about you tell me your case?
Well, in our submission, what JNFX envisaged was a document that on its face, a freestanding document that's...
Why? What's the magic of the word instrument that says it has to be freestanding? What does freestanding mean anyway? Let's go on to the next one. Signed. What does that mean? Is you saying that has to be wet ink?
There's an argument that that's the case, yes.
What is it your case?
Our case at its highest would be yes.
Right. And a duly authorised representative. So Mr. Mervyn describes himself as head of global markets. Why isn't he duly authorised?
Yes, but here, with respect, the Deputy Judge is necessarily approaching this question on the basis that Mr. Mervyn does not have actual authority. What the Judge is looking at is the question only through the lens of whether Mr. Mervyn had ostensible authority.
Right.
Why does that raise a separate question? Because if you say, I'm only going to be bound by contracts signed by my authorised agent, but I hold out X as being my authorised agent, and whether he is or not, you're bound by the contract because of ostensible authority. I don't see how the question of whether he's duly authorised is a different question from whether he has actual or ostensible authority.
But
It's the same question, isn't it? Or have I misunderstood that?
JNFX's position is that Mr. Mervyn did not have actual authority.
Yeah, no, I understand
that. Before the Deputy Judge, the claim in deceit is only addressed on the basis that Mr. Mervyn has ostensible authority. It's accepted that the question of whether or not he had actual authority is a triable issue. And so the deputy judge is looking at, or ought to be looking at, whether or not there's a real prospect of Mr. Giwa not establishing at trial on all the evidence that might become available.
Ostensible authority. Yes.
Ostensible authority.
All that I understand.
Yes.
I don't understand how the email footer changes the inquiry. I can see you've got a point on whether an email can be an instrument, but and you may have a point on whether it can be signed. But suppose signed means you put your name at the bottom of it, and suppose instrument includes an email. Well, Mr. Mervyn is being held out as the head of global markets for JNFX with a JNFX email with a JNFX footer. Whether he is duly authorised or not doesn't seem to me to raise a separate question from whether he has ostensible authority or not. Because if he has ostensible authority, then he is authorised for these purposes. If I say I'm only bound by contracts entered into by my authorised agents, that must include those agents where I have conferred ostensible authority on them, even if I haven't conferred actual authority on them. Or would you say it means, regardless of any holding out, that means that they have to in fact be duly actually authorised?
I think I'm in danger of eliding two questions. One in relation to whether or not there's a contract, and then secondly in relation to ostensible authority for the purposes of making representations here. And obviously,
well, we can assume for these purposes there's no contract, because as you've rightly emphasised, the contract claim wasn't pressed for summary judgment. So for these purposes, we can forget the contract.
And the reason we refer to this footer in the context of ostensible authority is in our submission, the existence of that footer puts the recipient on inquiry, for want of a better expression, as to whether or not the person they are dealing with has authority to make the representations that are sought to be being relied upon, in circumstances where those representations are supposedly being made in relation to alleged contracts.
And this point is rather double-edged, isn't it? Because here we have an email emanating on the face of it from JNFX, which is the body which does the holding out.
No, absolutely. And we don't shy away from that.
And we also know that Mr. Merlin had a consultancy agreement with JNFX, which is exhibited in evidence in our bundles.
Yes, and it's accepted that there's a tribal issue in relation to that consultancy agreement as to whether or not he had actual authority. So
if we're looking at ostensible authority, well, I mean, you look for ostensible authority in something emanating from JNFX, and on the face of it, an email sent on their own, with their own footer and their own typeface and so forth, appears to fit the bill, doesn't it?
Well, we don't shy away from the fact it's the JNFX email address. We don't shy away from the signature block and the type that is used. In the witness statement evidence that was before the deputy judge, and indeed in the defence, I think issue is taken with what that title would have meant or how that title would have been understood in the context of the market. Can I also, just so I can complete the submission in relation to ostensible authority, very briefly take your lordships to two short passages of two authorities in relation to the inquiry that the court, we say the deputy judge, should have been carrying out in relation to ascertaining whether or not there was ostensible authority. Because we say that the existence of that footer feeds into that inquiry, and why we say whatever the judge may have thought about the likely outcome on this issue at trial, when it had before it all of the relevant communications and a clear visibility in relation to what Mr. Mr. Giwa and multi-choice thought, even if the deputy judge took the view, as he plainly did, that that JNFX was likely to lose on the issue of ostensible authority, it's another thing to say that all the documents only go one way, and that there's no real prospect of that not.
Just before you do that, can we just look at one more? 352.
Sorry.
Now, I assume this has got the same footer on it, although it's been cut off in the way that it's been put in the bundle. But what I'm more interested in is the fact that this email of the 1st of 20, which is 1st November 2020,
Sorry, forgive me, I missed.
Page 352.
Oh, no, it was what you said that it refers to, and then.
There's an email. We don't have the footer on this page
Yes.
because it's been cut off. But let's assume the footer is the same. It's dated the 1st of November. And what interests me for present purposes is that, again, Mr. Mervyn describes himself as head of global markets. And one of those who's copied in is Nathan Eisenberg, who I understand to be one of the directors of the company.
Yes.
And there's no email from Mr. Eisenberg saying, whoa, Mr. Mervyn is not head of global markets for us. He has no authority to represent us. Please disregard.
First of all, lest I otherwise mislead the court, we don't say that the footer is on all of the emails. I can't tell you whether it's on this email or not, but it's not in dispute that it's on many of them. I just make that by way of clarification, lest I'm otherwise misunderstood. Nor is it in dispute that it was known that Mr. Mervyn was using that title. There is an issue as to what that title would have inferred in the relevant market in which they were dealing.
He attaches a signed copy of a contract.
Yes, but not a contract which is said by Mr. Giwa to be relevant. Can I please just show you, Lordship?
And the compliance department is copied in as well.
Yes, and insofar as know your client information was being dealt with, and that would be perfectly ordinary. And to be clear, JNFX's position, as it's been set out in the evidence and the defence, is not that it has no involvement at all in what has happened, but that Mr. Giwa's role was to, in effect, source business, the business of JNFX being, in this context, the provision of remittance services. So JNFX, in effect, makes a commission if somebody uses JNFX in order to make payments in US dollars. And JNFX's case on the evidence that for JNFX itself to have entered into foreign exchange transactions in relation to conversion of Naira to US dollars would be illegal as a matter of Nigerian law, and that is the reason why it would not have done it. They also contend that that is something that should have been known, and that that's relevant in considering whether or not Mr. Mervyn would actually, or ought to have been regarded as having ostensible authority to bind JNFX to a contract. All of that, though, is something that gets dealt with, or will get dealt with at the trial of contractual claims, because the triable issue in relation to illegality and the analysis of all the contractual documents is something that needs to take place further down the line.
Can I understand why these putative contracts are said to be governed by Nigerian law? Is that common ground, or is that?
It's common ground that there's a tribal issue about that.
There's a tribal issue that they're governed by Nigerian law?
Yes.
What is your case on that? JNFX is an English company trading from an address in London. Am I wrong?
Well, can I just forgive me? I was firstly going to say I'm going to, for the moment, if I may, rather duck that question, because I did not appear at the hearing below, and I'm obviously focusing on the appeal as it's presented, and it's accepted that that is a matter that's relevant for trial. So I'll be perfectly frank, it is not something that I have focused on for the purposes of today. Marlena Junior is about to tell me something. If I may just turn my back for a moment. Marlena Junior reminds me that the question, and I think I may have misspoken earlier, the question is whether it's because it's unlawful, because it would be, on our case, unlawful as a matter of Nigerian law for those contracts to be enforced, it becomes unenforceable. But
is that the case only if the contract is governed by Nigerian law? Or is it said that somehow the Nigerian law affects the legality of the contract even if it's governed by English law?
I'm in danger of shooting from the hip, which particularly in this court I really don't want to do. I'm also mindful of the time, but it's certainly a point we'll take on board.
Thank you.
If I then just very briefly take your lordships to the authorities bundle. Firstly, and again, I appreciate these authorities may be well known to the court, but I just want to put the submissions in context. The first is the House of Lords decision in Armagas and Mundagas, which is at tab 2 of the authorities bundle. And in particular, the relevant passage is at pages 92 to 93, which is at 777 of the report. Should be page 93 of the authorities bundle. And in particular, the proposition that I want to refer to is at C, where Lord Keith Pingle says, ostensible general authority can never arise where the contractor knows that the agent's authority is limited so as to exclude entering into transactions of the type in question, and so cannot have relied on any contrary representation by the principal. That's the first principle, and then the second principle we refer to is in the Supreme Court's judgment in Philip and Barclays Bank, which is at the very end of the authorities bundle. And in particular, it's paragraph 89 at page 440. In fact, just if I start at paragraph 86, one sees there under the heading limit of apparent authority, Midland Bank and Reckitt illustrates the limit on the principle of apparent authority, that it cannot exist where the third party has noticed that the agent is acting without actual authority. Principle of apparent authority protects the expectations of a third party which acts in reliance on a representation by a principal that an agent has authority to bind the principal. This protection is only justified, however, if reliance on the representation is reasonable. Thus, the doctrine will not protect a third party which has reason to believe that the agent is acting without authority and fails to make inquiries that a reasonable person would have made in the circumstances to verify that the agent had authority. And then picking that up at the bottom of the page, 4 lines up from the bottom, it says, no doubt the court should adopt the statement of the law in East Asia and hold the correct test to be that a third party cannot rely on the apparent authority of an agent if it failed to make the inquiries that a reasonable person would have made in all the circumstances to verify that the agent had that authority. And it's in that context, in our submission, we say the Deputy Judge failed to give sufficient weight to the relevance of the footer at the bottom of the many emails, and also failed in our submission to take account of all the evidence that might reasonably be expected to be available at the trial following full disclosure by the respondent and by multi-choice in relation to supposed entering into of the underlying contractual claims and variations.
It seems a little odd that your client company should be called FMFX if FX is something it's not allowed to do.
The illegality aspect is in relation to Nigerian Naira, where my understanding is there are particularly strict controls in relation to exchange of that currency. Well, it will in our submission be that that's a matter that Mr. Giwa would or should have had in mind, and indeed he would be cross-examined at trial in relation to what he was aware of in relation to constraints, in relation to the conversion of Naira. And again, in our submission, in circumstances where those contractual claims are all going to trial, the trial judge will be looking at all the relevant evidence, would need to make determinations in relation to how the contracts are formed, the details and so on. As part of that, plainly all the evidence would be before court in relation to what Mr. Giwa knew, what was said, and Mr. Giwa would be tested in cross-examination as to what he would have taken from the footer, what he ought to have taken from the footer, and what inquiries he ought to have made in relation to whether or not Mr. Mervyn had actual authority in circumstances where, as I say, it has to be accepted for the purposes of the assessment or summary judgment, or the summary judgment has to be approached on the basis that he doesn't have actual authority. This one's just looking at ostensible authority. Now, I've already made the submission that Deputy Judge may well have thought that the case on ostensible authority, I think the judge's words are overwhelming, may well have thought that when it came to trial, JNFX would be perhaps unlikely to succeed on the ostensible authority on the basis of the evidence before him. But that's not the test for whether or not summary judgment should be entered into, and say in any event we submit failed to take into account the fact that all of the relevant documentation and all evidence would be addressed by the court in the contractual claims trial. As to how the judge makes the finding in relation to ostensible authority, one sees at 34 page 174 of the core bundle. The judge there says that he agrees with Mr. Giwa that the evidence acts with ostensible, if not actual authority, is overwhelming, and then cross-refers to paragraphs 19 through to 69 of Mr. Giwa's skeleton argument, which he then doesn't repeat. So we don't have an analysis of all the various factual matters which are sought to be relied on. The judge just says reliance is there placed on a wealth of matters, including the email block. But it goes on to say, so it's also clear Mr. Green and Mr. Eisenberg were aware from having been copied in, and says it's a point your lordship's made to me that there's no apparent disclaimer of the role within those emails. But the deputy judge is there in effect making, it seems, findings of fact on various evidence to which he has been referred, which address, and if one were to look at the detail, the paragraphs of Malone and Friends' skeleton below in relation to the evidence that's relied upon, they address matters such as the alleged state of awareness of the directors of JNFX as to the effect of or implication of various communications which they sent or received, and indeed which they dispute. But the directors themselves have had no opportunity to give oral evidence in relation to those matters, and their oral evidence and the documents would be examined at trial in relation to the contractual claims. And we do submit that the footer is relevant in that context, because what the trial one would also want to be looking at what it was reasonable for Mr. Giwa to have considered in the full circumstances of the exchanges. Moreover, what Mr. Giwa was telling MultiChoice in relation to what Mr. Mervyn's level of authority was, also bearing in mind there's a question of whether or not, or at least a tribal issue as to whether or not those contracts would be illegal under Nigerian law. But we don't have disclosure of communications, which one can reasonably assume would come to light, between Mr. Giwa and MultiChoice as to what they thought in relation to Mr. Mervyn's state of authority. There's a submission made, which I just acknowledged for the moment, in the respondent's notice. They aver that the ostensible authority finding should be upheld on an additional ground, on the basis that they submit JNFX previously advanced a case that Mr. Mervyn did have ostensible authority in a defence in another set of proceedings that they refer to. It's probably a point best left for me in reply, but just to be clear, JNFX was not a party to those proceedings, and indeed the claim against Mr. Green was discontinued, but I'll come back to that as is appropriate once my friends made those submissions. But on any view, as we submit, by seemingly taking into account a whole wealth of factual material, which included how he perceived the director should have reacted to various communications, the judge was, in our submission, in error in conducting a mini-trial on the evidence. And very similar submissions then fall to be made, obviously in relation to ground 5, which is the incorporation of JNFX's standard terms. And obviously I'm at real risk of repetition. But we say, Judge
Yes,
F.
well, can you help me on the evidential
Sorry.
position here? Because I had a quick look at the document that is relied on, and I used the word document advisedly.
Sorry.
So, as I understand it, it's Court Bundle, tab 13, page 321.
Yes.
Now, this is a printout from a page of a website. One can see that the printout is dated 9th February 2022, so after the relevant dates. But leaving that aside, one knows that this is certainly not the home page because you can see that from the URL that's in the gutter. One has no idea from this document how you arrive at these terms and conditions from the home page, or what it looks like to the user who first alights on the home page. Moreover, there's something very odd about it, because if you look at the top, it begins with a phone number, an info@jnfx.com, and then main menu. So it doesn't even seem, it's clearly not a screenshot. It doesn't seem to be a direct printout from the relevant web page. And as I say, what the navigation is wholly obscure. So how do we know that any user who goes to the home page of the website gets here before one even gets into the question of what is actually in the contents?
Obviously, I fully take on board all of those points. The way in which it's been produced in this bundle is, I accept, unfortunately, it appears to be, I think one calls it an HTML printout from the website address, because one sees in minuscule font at the bottom the HTTPS address at the bottom. I had not understood there to be any dispute that these terms and conditions are readily available.
They may be somewhere to be found, but that's not the question. The question is, how does the user, the visitor to the website, know that they're there? What's the navigation?
Well,
because the fact that they are, located at some obscure location on the website doesn't mean anybody would ever know that they're there, let alone find them.
In my submission, when one looks at and it may be that the only solution is to obtain your lordship's screenshots to the extent that is of assistance, but where one sees the "you are here" bit, and then one sees one home, which is a hyperlink because of the way it appears, and then the two little arrows, application terms and conditions. My understanding is that indicates that one navigates to this page from the home page.
That might be right,
yeah,
but even if that is right, it doesn't tell you how you get there.
No, but one does see at the bottom, obviously, the email address which this page correlates to, and one can see that.
Sorry,
the very bottom, one sees https://jnfx.com/application terms and conditions.
Yes, so there is a page on the website with
Yes.
these terms and conditions, but that's not the question.
I'm not sure I can answer your Lordship's question any more than I can without straying into supposition, which I shouldn't do.
Quite.
But I can make this submission that these are plainly the terms and conditions which are on JNFX's website. That's a
Yes,
personal
but where's
website
the evidence
address.
that any visitor to the website will be led to this page?
I can't point your Lordship to that at the moment, but as I say, my understanding is it was never in dispute that these terms and conditions are readily available.
Yes, but if they are on the website, but in such an obscure place that nobody ever finds them, what use is that?
Well, with respect, if that was the case, that is a position one would have expected the respondent to take, as opposed to taking a position that they don't apply.
But can I ask a more basic question? If it is the case that contracts are made by email or made orally on the telephone and confirmed by email or WhatsApp, what is there to direct Mr. Giwa to the website at all? It may be right that if you go to the website, it's perfectly obvious that these are the terms and conditions. But if you never get to the website, that's irrelevant, isn't it? I mean,
Yes, as a matter of submission, that may well be right. The submission, or the point we would make here, though, with respect, is that the JNFX's website address is on every email that Mr. Mervyn sends. So the address and the link is on the footer of every email that's sent. But also, one is still left in our submission with the point that it would be reasonable to expect Mr. Giwa to be looking at the website, dealing with transactions of the magnitude that he's dealing with, and reasonable when one's dealing with who they believe to be the contractual party to identify what the terms and conditions are.
Yes, but this is why, as an elementary point of evidence, what you have is a printout of a screenshot of the website, and which will demonstrate that there's a big red letters on the website that say, "See our terms and conditions, click here." And that's the evidence that is wholly lacking.
I can't do any more than make my submissions on the evidence that's available. But as I say, the submission I've made to my Lord Justice Nugee's question is that one ought to be expecting Mr. Giwa to have given consideration, and indeed multi-choice to have given consideration in the course of their dialogue with JNFX as to what the relevant terms and conditions were, and indeed in our submission, it would be our submission at the trial, that it would be reasonable to assume that JNFX, if they thought they were dealing with JNFX, had standard terms and conditions. The reason we say the terms and conditions are relevant or would be relevant is the provision which is in clause 13, which in our submission relevantly provides that monies, and unsurprisingly provides that monies are required to be paid into an account of JNFX in order for JNFX to be responsible in respect of those monies. And plainly no monies here are ever paid.
Sorry, I'm a little slow. I've seen clause 13. Where's the definition of trade?
Definition of trading account, forgive me, I should have mentioned that. The definition of trading account is at page 326, where it says it means a bank account in the name of JNFX. And again, I'm not advancing a case that the Deputy Judge should have found that these terms and conditions applied, or that the Deputy Judge should have found what the effect of these terms and conditions are. The submission that we are advancing is that the Deputy Judge should not have entered summary judgment in circumstances where
Do you accept
Sorry.
that that you have to have a real prospect of establishing that the visitor to the website would be alerted to the existence of terms and conditions and would find this document.
Not as a complete answer, no, I wouldn't accept that.
So
I
you say
accept
you can bind people even if people will have no idea
I know.
that this document is there.
Forgive me, I may have been answering a slightly different question. At trial, yes, I do accept that is an issue that the court would need to effectively rule upon. And but the point we're making here, in the context of the summary judgment application, is that it was reasonable.
So the proposition is that the judge is supposed to assume that evidence is going to turn up at trial, even though this is your website, the only people with control of it are you, and therefore you're the people who can prove what the visitor to the homepage sees.
Well, in our submission, there was no dispute before the deputy judge that these terms and conditions are on the website, that they would be found on the website. And our case is it would be reasonable, bearing in mind the authorities I've taken the lordship to in relation to the inquiries that need to be made, it would be reasonable to require persons who thinks they're dealing with JNFX to ascertain what the terms of trading are, particularly when one's dealing with financial transactions such as this. But for the purposes of the summary judgment, the overarching submission is simply that the deputy judge was wrong to reject these arguments outright. That the essence of the submission is that this should have gone to trial. Ultimately, that's what all of our grounds of appeal are, under the guise of, that the deputy judge should have left all of these issues to be dealt with at trial.
Okay.
My learned junior rightly reminds me that the averral in the defence of JNFX is that these terms and conditions, and I appreciate what your lordship's already said in relation to their presentation in the bundle, but the averral in the defence at paragraph 30 is that these terms and conditions were published prominently on JNFX's website. And as I say, I've been approaching the submissions today, and my understanding was the case before the deputy judge that that's not in dispute. But obviously I hear what your lordship said in relation to the presentation of how the material appears in the bundle.
Can I go back to the, I'm sorry to take you back, but ground 4, the ostensible authority point.
Yes.
I've been looking at some of the emails, but there's one in the second volume of Supplementary Bundle at page 394. This is when things have started going wrong. This is October 2021. But Mr. Giwa in the middle of the page writes not to Mr. Mervyn but to Mr. Green, although he copies in Mr. Mervyn. We really need to ensure the payments go out today. We have no other excuse to give the beneficiary. And the response from Mr. Green is, I completely understand it's very important. Sorry, if it's very important for me to complete our commitment so we can start to repair our business relationship. And I think there are other emails along similar lines. Why is that not quite powerful evidence that the directors of JNFX, far from repudiating the commitment entered into by Mr. Mervyn on their behalf, are endorsing the fact that it is a JNFX commitment which leads to a business relationship between JNFX and Mr. Giwa or Mr. Giwa's beneficiary?
Well, there's a whole series of emails in which Mr. Giwa says should be construed one way and JNFX should be construed another way. JNFX's position is its responsibility is to transfer the monies to MultiChoice once it has received them, and it's Mr. Mervin's responsibility for the US dollars to come into JFX in the first place. And that insofar as it's talking about the business, JNFX is talking about its business relationship with MultiChoice, it's in respect of the onward transfer or the remittance of those monies. And Your Lordship will just bear with me a moment. So if one goes to page 396, and I'm very conscious there's a real danger in sort of cherry picking points and making isolated submissions, and actually in our submission all of this goes to our overarching submission, that all of these need to be considered in the round, in the context of a trial, when the individuals who've sent emails or been copied on emails and allegations are being made in relation to what they should or shouldn't have done by way of response is a matter which ought to be tested by reference to the oral evidence at trial. But for example, at page 396, on the same day, later in time, one sees an email from Mr. Green in the middle of the page, where he says, Dear Uncle Ashe, which is Mr. Mervyn, is still checking for the funds, and I just want to let you know I'm on top of it, my end. Their end being in relation to the remittance once they have received them. And indeed, at page 383, the very bottom, one has an email from Mr. Eisenberg, who's the other director, where he says at the bottom, I confirm that as soon as the USD arrives, we'll send it out, as per Ashley's email below. Now, I have to accept that a number of these emails can be read in different lights. JNFX says they should be read and understood in one way, Mr. Giwa says another way. But again, I come back to the point that what in our submission that demonstrates is all of these emails should be considered in the round-up trial in light of oral evidence from the relevant recipients and senders.
Thank you.
And then, finishing up very swiftly in relation to ground 5 and on the terms and conditions point, again at risk of ad nauseum repetition, whatever the relevant terms and conditions which do in fact apply to the contracts is a matter that will be determined at the trial of the contractual claims. Ground 6 concerns the Deputy Judge's finding on quantum. I've already addressed your Lordships in part in relation to the significance of this, and in particular I've addressed your Lordships in relation to the very lengthy reconciliation narrative in Schedule 2 to Mr. Giwa's first affidavit, which Mr. Giwa produces for the purposes of seeking to calculate the alleged shortfalls in US dollars and relevant returns of Naira, and I've made the point that that narrative is itself beset with assumptions, and after the event analysis, in the absence of a complete set of supporting records. Page 166 of the core bundle, so tab 6A, sorry, forgive me, that is a misreference, I'm so sorry. sorry, it's not the core bundle, it's the first volume of the supplementary bundle, page 166. One sees in paragraph 73, Mr. Giwa there explains the evidential basis for what are said to be the undelivered payments. It says, over the past 4 months, with the assistance of Peters and MultiChoice, I've attempted to reconstruct, to the best of my abilities, with as much detail as possible, how each order for currency exchange was placed by MultiChoice Nigeria and the efforts to reconcile the monies received to the agreed figures. And this is the basis on which I've been able to establish that the funds the defendants owe and or have misappropriated, and refers to the length of the resulting narrative, which I've already shown your lordships, and indeed I've already shown your lordships the judge's own conclusion in paragraph 19 of the judgment that he accepted that Mr. Giwa's reconciliation is not perfect and that there may be room for argument about the precise amount of the shortfall. And of course, as I've said ad nauseum, that shortfall itself can and will only be calculated at the contractual claims trial. Nevertheless, despite the contractual claims going to trial and the findings in relation to shortfall and an assessment of the quantum being determined at that stage, the judge somehow finds at paragraphs 45 to 47 of the judgment very specific numbers in relation to shortfall. And in particular, as it ends up being inserted within the order, he finds that there is that there's a shortfall of 334,530 naira, which arises in respect of the 5th contract. And he finds 3,065,000 and 800,000 naira is due in respect of the 6th to 9th contracts. And then obviously the full amount in relation to the 10th contract, resulting in him reaching the conclusion that JNFX is liable for the sum in excess of 7 billion naira. But in our submission, he makes those findings in relation to shortfalls in circumstances where he doesn't make findings and accepts he shouldn't make findings in relation to the terms or existence of the alleged underlying contracts, whether as agreed or allegedly varied. And he does so without any considered analysis of the composition of the sums said in the reconciliation narrative to have been paid by JNFX, to have been paid by Mr. Giwa and MultiChoice, referable to those alleged contracts, and for which so it's alleged reciprocal US dollar exchange or refund of naira is alleged to have been received, and doesn't deal with any of the matters which we addressed in paragraph 19 of our skeleton argument in relation to conclusions that could be reached in relation to shortfalls. So, save in respect of the alleged 10th contract, for which it's obviously claimed there's no US dollar exchange or Nigerian naira refund, the quantum in relation to the naira that's supposedly been paid, for which no refund's been given and no reciprocal US dollars have been provided, in relation to the 5th and the 6th to the 9th contracts, is something that in our submission can and should only be computed by a considered analysis of all the relevant terms of the contracts said to have been entered into and subsequently varied, and indeed the precise flows of the various funds, including the refunds, which the respondent has made assumptions about. And all of that evidence is something which would need to be and will be tested at trial. It's also relevant, points we've already made, that the payments of NERA in the first place are never made to JNFX's own accounts. Mr. Giwa was given evidence about the complexity and incompleteness of the reconciliation exercise. He's altered his account in the course of the proceedings in relation to the shortfall. He's admitted in his reconciliation narrative that contemporaneous notes refer to payments which he's confident, payments made by JNFX which he says he's confident is not received. So we've made the points in paragraph 19 about difficulties in assessments in relation to shortfall. And so instead what the judge appears to have done is just take as read that those figures are right and looked only at a separate additional credit which was raised by JNFX as something which they thought hadn't been taken into account and ought to be taken into account. And in doing that, in our submission, the judge has wrongly deprived JNFX of the ability to test Mr. Giwa's reconciliation narrative with the benefit of full disclosure, not just from the respondent, but from multi-choice, and indeed from potentially from the third party that hold the relevant accounts into which the money is said to have been paid and passed through, and indeed cross-examination of Mr. Giwa. And by doing what the Deputy Judge has done, with respect, it creates a real risk of inconsistent findings on the shortfalls when one gets to the trial on the contractual claims, such that even if the judge had been correct to grant summary judgment on liability in relation to the claim for deceit, which is on our submission shouldn't have done, he should not have gone so far as to make findings in relation to quantum. On any view, the issues in relation to quantum should have been left to trial. The importance in our submission of that and the need to test the evidence is highlighted in our submission by the additional clip of correspondence, which I mentioned at the outset of the hearing, which we have made an application, our clients made an application to have admitted to the supplementary bundle in circumstances where there are documents that were before the Deputy Judge below, but which, as is explained in the correspondence, are now understood to have some relevance in circumstances which were explained in the correspondence. Now, the additional clip of correspondence is 22 pages. 8 pages of that are key contemporaneous documents which were before the Deputy Judge below. And my understanding is that the addition of those documents to the supplementary bundle is not opposed by my learned friend. But perhaps if I just if I can address your lordships just in effect only as in relation to what we say they show, but in essence we say they show further credits that can be seen on the statements for which no explanation has been given and which haven't been taken into account in the reconciliation narrative. So the clip, forgive me, I'm calling it the clip of correspondence. It's in essence correspondence with the documents attached, but it should be paginated in the bottom right-hand corner with the first page being an index. It's paginated as number 1. But if I could just go to page 2, which is the letter by way of email from my instructing solicitors on the 4th of April. And in paragraphs 4 through to 9, it's explained by my instructing solicitors that they have identified credits which do not appear.
So you say the documents were in front of the judge.
Sorry.
So this seems to be submissions that could have been made to the judge but weren't. Is that correct?
Yes, I'd accept that. Yes, so the documents which are enclosed with the letter are documents which were before the judge, and they're documents which were redacted bank statements. From Mr. Giwa, which show refunds being made by Mr. Mervyn from Mr. Mervyn's accounts to Mr. Giwa. So those bank statements, one sees paginated number 6 through to 13. The first point that's made is in paragraph 6 of my instructing solicitor's letter, and it refers to a credit to Mr. Giwa's account on the 9th of February 2021, which is at page 9 of the additional clip. And in fact, one sees on that page, which is obviously heavily redacted, which is one of the difficulties that JNFX has, because these are not JNFX's documents. But one sees credits there. And the question that's raised is in relation to $1 billion of Naira that one sees towards the bottom of the page on the 9th of February. So 2 payments of 500 million Naira, credits going into the account. But those are not included within the calculation of refunds. And I'm very conscious of the time, and what I would invite your lordships to do is just to read the paragraphs of the letter in which the queries are set out by reference to those documents, asking questions about refunds which on the face of it don't appear to be accounted for. The response to those queries being very simple from Mr. Giwa, which is just, they say they've already given full credit and don't propose to engage in the correspondence.
They also say you've had this material since October 2022.
And I accepted that in response to your lordship's question. Yes. But we say that this which appears to show very significant refunds of Naira, which are not on the face of it taken into account in the calculations, imperfect calculations that have been made by Mr. Giwa, demonstrates that there needs to be a proper assessment of quantum, and indeed there will be in our submission a proper assessment of quantum. We would invite your lordships to take into account that further information that's there. And really the overarching point is one I've made, again I say ad nauseam, that the judge wrongly made findings of fact without the analysis he should have carried out, that needed to be carried out, in relation to working out what losses could really be established. And the findings he makes in relation to quantum, the judge himself says is done after some initial hesitation and expressing the view that it's not straightforward. But he appears to have approached it on the basis that all he needed to do was to look at positive submissions made by JNFX in relation to particular credits that they had suggested ought to be, or at least raise queries in relation to whether they ought to be taken into account. And what the judge doesn't do, not least because couldn't possibly do in the time available, is work through all the various movements of monies to establish what are the shortfalls, what is the position, what is the narrow that's outstanding. That just isn't done. And the judge needed to make positive findings as in relation to what those shortfalls were in order to...
Well, I don't understand why in principle there's anything wrong with that. I mean, I take your point about a mini-trial, and that's a general point which holds is good or bad regardless, but a trial is going to be the same, because Mr. Giwa will go into the witness box. He will say, here's my reconciliation. It's the best I can do, but I believe it's tolerably accurate. It's not perfect, but it's reasonable. And unless there's some challenge to that coming from your side, the judge is going to accept it.
Well, Mr. Giwa is obviously put to proof in relation to the content of that. And Mr.
To be sure, but my point to you is that's how he proves it. He goes into the witness box and say, here's my reconciliation.
Yes.
And that will stand and will be accepted unless there's some challenge to it.
Yes, but by...
So what's wrong with looking at the challenges and saying, well, are there any? And if so, do they have any real prospect of success? Subject to the mini-trial point, which of course is stands separate.
And because here, that view is being taken in circumstances where the trial of the contractual claims is yet to happen. So, and in order to determine what naira Mr. Giwa says has been paid, not addressed by way of reciprocal payments in US dollars, and not refunded through the various mechanisms that he identifies, that one has to go through that exercise in order to identify the quantum of the deceit claim. And yet, at the summary judgment stage, the judge is proceeding on the basis that that analysis in relation to all these underlying contracts and where one ends up in terms of the shortfall, what are the terms, how does one calculate the naira and US dollars, and how does it all net off, is something that's going to happen in the future. And so it was not appropriate in our submission for the judge to effectively determine specific sums. That's the point we make, that even if he was right, and in our submission we say he wasn't right, to make the decision on liability, the question of quantum should have been left over. Moreover, in fairness to JNFX, because Mr. Giwa himself says it's taken months to produce all of this, he's the one that's got all the documentation. JNFX needs to look at it. Monies don't come directly to it. JNFX, dare I say, rather surprised by what's happened, has taken steps to try to work out where some of this money is. You've got the evidence from Mr. Elam in relation to some inquiries that they've made in relation to ProTrade. But when one gets to trial, it is reasonable to expect that the evidence that would be available to the judge would be much greater, because one would have full disclosure of information.
Okay.
And moreover, the effect of what the Deputy Judge has done by making findings in relation to shortfall is to create a position where one can end up with inconsistent findings at trial. Mr. Giwa himself has said on the reconciliation narrative it's the best he can do at the moment. The figures have already changed in the course of proceedings. And so one ends up in a position where one may well have inconsistent findings within the same proceedings as to what the supposed shortfall was. Leaving aside the fact that the submissions I've made that the judge shouldn't have reached those conclusions in relation to shortfall at all.
Right.
Can I just turn my back for a moment? I'm going to avoid further ad nauseam repetition unless there's anything else your lordships want me specifically to address. Those are submissions in the conclusions.
No,
as expressed
thank
elsewhere.
you very much. Mr. Brown.
Well, also, I'd like to address you first on my learned friend's application to adduce fresh evidence. And your lordships have already seen the Flitcraft decision, and paragraph 46 is really the key part of that. I'd just like to draw your lordship's attention to one other aspect of it, just before I launch into the application proper. And I think we find it at tab 5 of the authorities bundle. And at page 217, we see the extract there from Lord Justice Arden, as she then was, her decision in Aylwin and Taylor and Johnson Garrett. And she then in turn quotes from Lord Bridge and Ladd and Marshall. And we see there, so obviously will be well known to your lordships, they talk about the standard of diligence, preparing his case in operation to a summons for summary judgment, especially if under pressure of time, would not be so high as that required in preparing for trial. But moving on, he says, I see no injustice at all in requiring the defendant to use such diligence as is reasonable. So it's not necessarily the case that the bar is always lower where one is dealing with a summary judgment application. All depends really on the facts. But dealing with that question of whether or not there was any time pressure, there was not here. What happened was that in October 2022, Mr. Giwa obtained a freezing injunction against Mr. Mervyn and others, but not against JNFX. And then Giwa 1, which was a pretty voluminous statement to which was appended the narrative which you've seen, was served on JNFX, so they had it as of October 2022, and they effectively had pretty much all the evidence that we eventually relied upon in the summary judgment application, not least because Mr. Tickner, when he served his evidence in support of the summary judgment application, appended Giwa 1 for a second time, effectively. And so with that background where we say really this isn't a strong case for there being a looser approach to what reasonable diligence demands.
I'm sorry, I didn't get a note of how long they had. When did they get a copy of your evidence?
So October 2022.
So it was served at the same time as obtaining the freezing injunction against the other defendants.
That's it.
And when did the summary judgment application come to be heard?
We actually have quite a helpful chronology in the core bundle. I think it's under tab 4, and we see the dates set out in these respects. Page 162. So the ex parte, following the ex parte hearing before Mr. Justice Miles, that was on the 24th of October. Everybody got served, and then over the page at 163, the summary judgment application with evidence in support issued on the 18th of September, evidence in response 17th of November 2023, and then another good number of months passed until the hearing on the 18th to 20th of March 2024. So that's really the chronology.
Thank you.
And turning to the first limb of the test that we see in respect of paragraph 46 of the Flitcraft decision, namely, was the evidence readily available for use or easily available for use at the interim hearing? We say that really, yes, it was, and so they fail at the first limb. And if we pull up the supplementary bundle, I think we could probably put Flitcraft away now, and it's volume 1. We go to tab 5B, starting at page 113. This is the second witness statement of Mr. Elam in support of the application. They say this, we've heard my learned friend speak about what the significance of this evidence is said to be, but it's set out at paragraph 7 on page 115. But the supposedly new evidence is then summarised onwards at page 121, paragraph 36. Going across paragraph 36, and its subparagraphs, there's no less than 12 different documentary references, but only one of those references is to the document derived from ProTrade. All the other documentary references are to documents that were readily and easily available to JNFX at all times. And just to skip through them, there's a reference at 36.2 to an email which Mr. Eisenberg himself is in on that email, so they plainly had that email at all times. At 36.3, that's a reference to our pleading, which before it was amended, they had as early as November 2022, which you see again in that chronology in the core bundle. At 36.4, there's an email. It's characterised as being an email from Mr. Giwa to Mr. Mervyn, but again, if one looks at it, it's at page 131 of this bundle. Mr. Eisenberg and John Batten, he's another JNFX employee, are in copy. So it's a document they had at all times. At paragraph 36.5, the first reference is to the wire confirmation that was apparently recently received from ProTrade, albeit in which circumstances we do not know, as I think Lord Justice Arnold has already noted. And then there's a reference in the same paragraph to a bank statement, which we see at page 128, which again they had at all times. It's their bank statement. And then onwards, we get another reference to the pleading at 36.6, 36.7. That's again an email from Mr. Giwa to Mr. Mervyn, but it's on JNFX's systems because it's sent to his JNFX address. 36.8, again it's the bank statement. 0.9, it's another JNFX email on their own systems. 0.10, our pleading again. So actually the only new thing is the ProTrade confirmation slip, which you see at 136 on to 137. But in fact that slip is superfluous in establishing what they say is the import of this supposedly new evidence. And as you've heard my learned friend say, they say this evidence establishes that at the same time as Mr. Mervyn was arranging the 10th contract, which JNFX never fulfilled, he did arrange for a trade for Technocrat to actually complete. But they had, at all times, the evidence that this trade had been arranged. And you see that at 130, Mr. Eisenberg copied. The quantum is a bit imprecise, it's talking about a 2.5 million payment. We know in the end it was 2.37 million. But there's Mr. Eisenberg being apprised of it. Same again at page 131, talking about the trade. So these were both available to JNFX at the click of a mouse, and they showed clearly that Technocrat was a client of Mr. Mervyn and JNFX's, and they didn't need ProTrade's assistance to learn that. And they don't need their assistance either to know what the quantum of the trade is, because it's in their own bank statements when it eventually goes out at 128. You see that on the 21st of September. So they knew, and they always had the evidence that the trade had been done and completed. And this is a statement in JNFX's own name. It's got the entirety of the transactions for September 2021. It's a crucial month in these proceedings. And there's no suggestion that JNFX didn't have access to this. So they suggest this information was uncovered only because of communications with ProTrade, but they were realistically uninvolved with the making of the payment to Technocrat. That was made directly by JNFX to Technocrat, And they must have known, as a FCA regulated entity, why they're paying out 2.37 million to them. So really, it's far-fetched to suggest that pro-trade were needed so as to elucidate for JNFX's internal knowledge why it made this payment. It doesn't send out payments like that with no idea as to who or why. That cannot be right. So it fails at the first stage, and the professed reason for it only coming to light at this stage doesn't stand up to scrutiny. If we look in Mr. Elam's statement, he states that JNFX started making inquiries in April 2024, and it had got all the information and analysed it within 2 months. And it issued this application in June 2024. So the information was readily and easily available before the hearing. And that ought to be the end of this application. But I'll address your lordships briefly on the second limb of Flitcraft, namely the standard of diligence. And again, if we go back to what Mr. Elam says, it's on page 117. He explains at paragraphs 17 and 18 there that JNFX hadn't yet got to the disclosure stage, and for that reason they didn't necessarily have the hook that might enable them to go after third parties for disclosure. I'm afraid we say the court can't really take that submission at face value, because if you go further on in the supplementary bundle to the statement that Mr. Elam served on the summary judgment application, it's at tab 6C, and it's page 274. If your lordships look at paragraph 11.3, in particular the latter half, where having mentioned Mr. Mervyn's dealings with cryptocurrency traders and providers, they say JNFX had and has no direct relationship with the banks and payment providers that Mr. Mervyn used in relation to the Naira transaction, and it is not in a position to require information from those banks and payment providers. So actually what happened at the time is JNFX gave consideration to getting disclosure from third parties, such as ProTrade, and decided not to. And even the explanation that we see here, in fact, at page 274, where it talks about JNFX having no understanding as to what Mr. Mervyn was doing, and JNFX having no involvement in these trades, as we'll see in due course, is belied by the documents that I'll take your lordships through. So the reality is that after the hearing, what JNFX did is do a U-turn. It's changed its mind about the merits of seeking information from third parties, and is now trying to do so, as Mr. Elam explains in his second statement. But all that shows, realistically, we say, is that they could have had a go at getting this information long before the hearing, had they only so chosen. The question of reasonable diligence that you see addressed in the Flitcraft decision really reduces to this. The reality is they put no evidence in at all, because, sorry, just stepping back, the significance of this application is said to relate to the falsity or otherwise of Mr. Mervyn's representations. But back at the time of the hearing, they didn't put any evidence in at all to suggest that Mr. Mervyn's representations, if made, were not made falsely. And if we stay at page 115, I can tab 5B. And look at paragraph 7 of Mr. Elam's statement. That's where he talks about the supposed significance of this evidence. What he said at the time of the summary judgment hearing is at page 271, sorry, page 294. That's where the statement is, but paragraphs 87 and 88, That's the extent of what Mr. Elam had to say about the deceit case in evidence before the judge below. And I ask your lordships to read it because it's quite revealing. And in keeping with that was their skeleton below, which you find under tab 4 of volume 1 of the supplementary bundle. And if one goes to pages 94 and 95, you see the extent of what they had to say about the deceit claim then in their skeleton. There's no hint of a case, of a positive case, to the effect that Mr. Mervyn's representations, if made, may not have been made falsely. Closest they get to is paragraph 73, whereas the judge found there's a misplaced reliance on an extract from Clark and Lindsell. So, if this was an argument they wanted to run below, reasonable diligence means they should have done so. And the reality is that after the hearing before the judge, they become much keener on making a positive case in this regard, and it's all an afterthought. Lastly, on the third stage of the Flitcraft test, we say this evidence is not half as probative as they seek to say it is. I'll come on to that in more detail when we deal with the falsity limb of the grounds of appeal, but in short, the technocrat payment was made effectively expressly because Mr. Giwa had made it a condition for releasing further funds under the 10th contract. If one looks at the supplemental bundle at page 325, I think we're right at the end.
I beg your pardon, could you give me the page again?
So page 325, it's under tab 6F.
Thank you.
I'll just ask your lordships to read sub 2 at the bottom there and over the page. You see at the bottom at 326 is on the 21st, 2.37 came in. Mr. Giwa said it's still short, but then over the page he sent the remaining sums due under the 10th contract, and you see them set out. Bear with me. In the core bundle, in the dates of payments, on page 232 under tab 9, And the very last payment after the Technocrat payment came in on the 21st was made on the 22nd for 1.2 odd billion naira, which I understand is worth about 2.5 million US dollars. So it was more than the Technocrat payment. So for all of those reasons, we say the application to adduce new evidence should be dismissed. On the other application in relation to the correspondence clip, I think my learned friends candidly accepted that everything in there relates to questions that could have been made prior to or at the summary judgment hearing, and whilst we didn't object to further correspondence going in, we do object to any attempt to try and rely on its contents as somehow being equivalent to fresh evidence. There's been no request for further information under CPR Part 18. There's no amendment to the defence to plead out credit for these sums. The timing of the correspondence has plainly been confected so as to give another point at this hearing today, and we say the content should be disregarded. But in any event, we have answered it. If one looks back at the letter that those instructing me wrote on the 1st of May, it's page 21 of the correspondence clip, we point out how, at paragraph 2, that they could have made these points long ago. At paragraph 3, we say in terms we've already given you credit for these sums. At paragraph 4, we explain you've missed something in relation to some of the questions you're asking about because you're referring to the wrong bank account statement. It's page 22 of the correspondence clip. So, for all of those reasons, we say both the application should be dismissed, and the documents in that further clip of correspondence doesn't take my learned friend anywhere further on this appeal. I'm assuming your lordship would rather deal with those applications later, and so propose to move directly now to the grounds of appeal. And to a large extent, those grounds find their answer in the evidence that the judge was shown below, and I'm going to intend in the first instance to rather unashamedly take your lordships through a certain amount of that evidence first. And I've noticed that your lordships have picked up some of the matters I wanted to alight on already, particularly in Supplemental Bundle Volume 2, but I want to do this in particular with a focus on the question of ostensible authority, and hopefully for obvious reasons, because if we don't hold on to that finding, not much else really sticks of the judge's remaining findings. So, briefly, if your lordships could pick up Supplementary Bundle Volume 2 and turn please under 8A to page 334. And over the page at 335, you see this early confirmation of a trade, which we say does evidence in sufficiently clear written terms both the payment representation and the use representation, albeit we accept for a different contract so we don't push it much. But more than that, we can see early on, you look over the page at 336, right from the start, Mr. Mervyn's being held out as the head of emerging markets. It's at the bottom there of 336. Just above, at the end of the email on the 21st of September, Mr. Mervyn is thanking Mr. Giwa for trading with JNFX Ltd. So plainly, right from the off, that's how Mr. Giwa would understand himself to be acting vis-à-vis JNFX. They're placing trades on his behalf, actually on MultiChoice's behalf. And what's also clear is that JNFX, through Mr. Mervyn at 335, is representing in clear terms that they can exchange Nigerian naira into dollars. They're not saying we can't do this because of reasons of illegality. Moving on under B, 339, you see Mr. Giwa writing on the 25th of September, thanking Mr. Mervyn for the trade he'd placed. Says, I intend on buying at least $1 million weekly from your company, and sets about making certain questions. So it's clear that Mr. Giwa views Mr. Mervyn as synonymous with JNFX at that early stage. And again, down in the email, we could see it's asking when is the latest day for the naira to reach your company. That's your selling rate. Talks about the dollar rate. So it's clear that he understands Mr. Mervyn's acting for JNFX in affecting naira dollar transactions, and that Mr. Mervyn's holding himself out as being able to do so. Now, I accept that at this point in time, this early, there's an unresolved question in the evidence as to whether Mr. Mervyn's holding himself out with the blessing of JNFX and its directors, or whether he's on some kind of frolic. But already, that last suggestion's unlikely, as he's writing with the title that we've seen from the JNFX email address. And it would be quite some fulsome frolic, because we see over the page, this is at tab 8C, page 340, there's a contract between MultiChoice and JNFX. And if you zip to the end at 348, you see Mr. Mervyn was on the signatory page on behalf of JNFX. There's no dispute that contract was not operative. But interesting, given this is in fact the only contract that we've seen that's been tendered on behalf of JNFX, is clause 3.2 of this contract on page 342, where it doesn't have an equivalent to the clause in the standard terms, to the effect that payments must be made into a JNFX bank account. It just says it needs to be sent in accordance with the settlement instructions provided by JNFX.
You said it was not disputed this was not operative. What was the evidence in relation to this document?
I think Mr. Giwa deals with it in the affidavit on the freezing injunction, and he said that ultimately it never came into force, and he checked that with MultiChoice. I mean, it does have certain oddities. If you look at 346, it seemed to envisage that there would be work done on behalf of clients of MultiChoice Africa. But MultiChoice Africa is effectively like Sky TV in Africa. And certainly Mr. Giwa understood himself to be acting for that company, not for separate clients of that company. We move on to page 349.
Sorry, what do we get out of this if it's a contract that never came into effect?
Really, you see, what you get out of it is that Mr. Mervyn was holding himself out as being capable to sign contracts on behalf of JNFX.
Although, in fact, he didn't.
Not on this one. But if we move on to 349, slightly separate point to the question of authority, here we have evidence as to the existence of contract number 1, and just doing the compare and contrast of when the contracts were entered into, and you can see it in the core bundle in our pleading. It's in tab 9, bottom of page 201 and onwards. We see when we say the contract dates were. So 29th of September was a contract for $2 million, and $2 million, and you see that being effectively confirmed in writing there by Mr. Mervyn on the 2nd of October. And that number never changed, even with so there was no question of an IRA refund on that one. Same applies to the document over the page 350. This is now contract number 2 for $5 million US. A pretty clear evidenced example, we would say, of the payment representation, the existence of which is not challenged in the grounds of appeal. And that's the $5 million one. And again, we have Mr. Mervyn signing on JNFX letterhead, head of global markets. And then we move to 351 under tab F. And this is one I think my Lord Justice Arnold picked up on. And it's very significant because what we see at 352, as your Lordship's really pointed out already, is Mr. Mervyn copying in both JNFX Compliance Department and Mr. Eisenberg, and just pausing there. JNFX is Jonathan and Nathan FX. So you go to Jonathan and Nathan's company, one would think, to get foreign exchange transactions done. And you see Mr. Mervyn copying all in, explaining that MultiChoice wants to trade approximately 15 to 30 million US dollars, that's sub 0.5, and that it's consolidating funds from various countries in Africa into USD dollars as a hedge against market depreciation. And if one goes back a page at 351, you can see that Mr. Giwa corresponds with Mr. Adigboyaga at MultiChoice, who writes back confirming these matters. And then Mr. Giwa himself then copies Mr. Eisenberg and the compliance department, Ms. Intera, who I think is also, it's Dinah Ginter, who works in compliance. So they're copied back in again, and it's crystal clear that MultiChoice wants US dollars in exchange for an African currency. And Mr. Mervyn, you see it at 352, is expressly asking for confirmation as to who can issue trade instructions. That's between the hole punches, 3 lines up from the bottom of the email. So it's clear they're looking to be trading African currency for dollars. Both Mr. Mervyn and JNFX are being held out as to Mr. Giwa and to MultiChoice, effectively as being well able to take care of exchanges of African currencies into dollars. And your Lordship's pointed out that you don't get Mr. Eisenberg or compliance popping up saying, hang on, we only deal with the dollar side of the transaction. We don't do this kind of foreign exchange. So they're giving their blessing to Mr. Mervyn, holding himself out as head of global markets and as someone well able to execute trade instructions on JNFX's behalf, to change African currency for dollars, and moreover to bind JNFX contractually, not least because Mr. Mervyn himself attaches a copy of the contract, 352. Now if you jump, just to make things a little bit less monotonous, to what JNFX said, not JNFX, I must be a bit more precise, to what I think it's, if one goes to volume 2, 8JJ, you see Mr. Green, the other director, got sued by a company called Greenovate Global Platforms Limited. And just pausing there, it's Mr. Green who signs JNFX's defences in these proceedings. And if one looks at 572, paragraphs 11 and 13, you can see, first of all, at 11, again, Mr. Mervyn is involved, held out as an employee of JNFX. 13 explains that claimant's understanding of what JNFX would do. And over the page at 574, you can see at paragraph 19, that at the end of August 2021, this entity paid over $1.1 million for exchange, worth of Naira for exchange into dollars. And if you look at paragraphs 21 and 22, you can see they never got anything back, apart from 100,000, so they were $1 million short. Mr. Green's defence, you see it at 578, you see it's 587, prepared by Mr. Wigley, also who prepared JNFX's defence in these proceedings. It's dated on the 19th of January 2022. And if you look at paragraph 11.3 on page 580, they set out positively what Mr. Mervyn did. It's worth a read. That's pretty much akin to our pleaded case as to Mr. Mervyn's role. And at 581, page 581, at paragraphs 13.2 and 13.3, you see the positive averment that JNFX can and could convert Naira into dollars, remit dollars to the relevant client, and the way it happened is further explained at 13.3. Claimant would remit the Naira, together with a sum in respect of any fees due to JNFX, into a Nigerian bank account nominated by or on behalf of JNFX. We know that's by Mr. Mervyn, because they explain that at 11.3, and JNFX would then cause the equivalent sum to be paid over. And of course, that's a case that's entirely consistent with the early indicator of Mr. Mervyn's authority as sanctioned by a JNFX director and its compliance department as early as the 1st of November 2020. Well, what becomes of that case, positively set out by Mr. Green when it comes to these proceedings? Well, you see it, it's back in the core bundle under tab 11, page 277. Lengthy paragraph number 13.5.3. The Lordships may have read it. It does bear reading all the way through. In particular, 13.5.3.2a denied that Mr. Mervyn arranged Naira dollar exchange transactions on behalf of JNFX, or that it had any authority to do so, but it did so with any knowledge and authorization of JNFX and its directors. Over the page, bottom page 278, JNFX would have no involvement with the exotic currency side of any such transactions, and was not concerned with or involved in the transfer of any Naira out of Nigeria. Well, that's completely incompatible with the communications of the 1st of November 2020 and with Mr. Green's defence, and matters get much worse in terms of the sheer weight of the documentary evidence falsifying this case. We go back to the supplementary bundle, volume 2, now it's tab 8J. Move on in time somewhat. Email from Mr. Giwa, copying Mr. Batten and Mr. Eisenberg on the 8th of April 2021, explaining MultiChoice wants a refund of a lot of Naira. By this stage there have been various shortfalls. JNFX has not been able to provide irrefutable evidence of payments. He wants the money back. So abundantly clear that Mr. Giwa was acting for multi-choice. At stake is the exchange of Naira. Mr. Mervin's charged with this, and you get no email from Mr. Eisenberg refuting Mr. Mervin's ability to act in this manner. He doesn't say, hang on, JNFX can't refund you Naira because we don't get it. Doesn't say that at all. We move on.
Sorry, where is the reply?
We don't get any reply from Eisenberg himself.
Right.
And then we go to 369. Similar timing, a few days later. Mr. Green's now in on the communications. Mr. McGee was saying, as a matter of extreme urgency, the funds in Naira meant for dollars for multi-choice must be returned this morning unfailingly. It couldn't be clearer what Mr. Giwa thinks is going on. Mr. Green doesn't pop up, saying, hang on, we don't deal with you at all. Our dealings are with Mr. Mervin. We don't deal with Naira transactions, we're only on the dollar side. We go to the next tab, should be N with any luck. On page 372, now this is a transaction that didn't ultimately happen, and you see Mr. Eisenberg and Mr. Green in on the communication from Mr. Mervin to Mr. Giwa.
Sorry, can you give me the page?
Sorry, 372, I'm sorry.
Thank you.
$30 million in the final line against NGN, that's Naira. Again, I mean, obvious points. They can see Mr. Mervin using his JNFX email address. They see him with the footer and his title. You can see it's for Naira to US dollars. Again, no squawk. And similarly, 375, 10th of May 2021. Payments for $1.8 million and $850,000 not being received by multi-choice. As a matter of urgency, please return the Naira. He's not copying Mr. Green and Mr. Eisenberg because he thinks they've got nothing to do with it. It's the opposite. And then we go over the next tab to P. And you see at the bottom, this is page 376, there's Mr. Mervin talking about, this is now evidence of the 9th contract. And he says we're going to have the receipt of the Naira on the 19th of May, an MT-103 on the 27th, and receipt of funds a few days later. And the MT-103 is a SWIFT proof of payment document. And what we have here, we say, again, is clear written evidence of both the use and the payment representations, getting Naira to convert into dollars, and it's going to go over to multi-choice, and we know that because we see the subject title of this exchange a little higher up the page, read multi-choice trade. And Mr. Giwa responds, it's extremely important for the client, it can only be multi-choice, but there are absolutely no delays. Over the months, payments from JNFX have been delayed, and it's affected multi-choice's business planning. And up the top, Mr. Mervin says this is understood and agreed. And again, so what you've got is Mr. Green in on the formation of the 9th contract. For it was quite clearly a currency trade for Naira to dollars. And he says nothing. It reflects the pleaded position in these proceedings. 379. This is still the 9th contract. The settlement timings have moved back. And again, Mr. Green is copied in. all the same points apply. Clear manifestation of an intent to deliver dollars to the multi-choice standard chartered bank account. That's the payment representation. No wonder they don't appeal the finding that it was made. And it's clear that in issue is a currency trade for Naira to dollars, with penalties to be in Naira. And of course, in all of these documents, you don't see a single reference to terms and conditions applying. And if one goes on to page 380, there's the confirmation that 9 million of that 9th contract is going to get paid, and Mr. Green's in on that communication too. We move on to sub S, and this is Mr. Giwa writing about the contract for First Bank, and he copies in Mr. Eisenberg and Mr. Batten. It's an order for $2 million. It's one of the biggest banks in Nigeria. He wants assurances from your firm. He's talking to Mr. Mervyn, but also talking about his firm. It can only be JNFX, about payment being delivered. And if you follow that chain all the way back to 381, to its final culmination, it's Mr. Eisenberg who confirms the final terms. That's the top. That's confirmed. So he's a party to this contract formation, agreeing the terms of the trade, agreeing to commit to the due date.
Which contract is this one?
This is with a different entity. It's First Bank. But it's one of the biggest banks in Nigeria. It's for $2 million. The penalty's in Naira. It's obviously a Naira-dollar exchange. And here's Mr. Eisenberg adopting this contract as JNFX's own. Cannot be reconciled with their pleaded position in this case. We then move on to the 10th contract, and this is under the next tab, tab 8T, and you can work the exchange backwards. Mr. Mervyn writes to Mr. Giwa, deliver the trade, this is on page 384, deliver the trade for 10 million to multi-choice on the 17th against payment credited today, 8th of September 2021. And Mr. Giwa seeks confirmations on that day. Notice that during crisis periods your partners are very quiet. Doesn't give me a lot of confidence they have the right impact or hold on events at JNFX. Nathan confirmed the First Bank delivery date, and up to now it hasn't been sorted out. You get your partners to buy into the transaction and their commitment. And Mr. Eisenberg responds, bottom of page 383, I can confirm that as soon as the dollar arrives we'll send it out. Mr. Giwa carries on, explaining the difficulties. This is what I need the company to be committed to. What has gone on in the last 60 days has been really, really bad. Again, we are committed to meeting the date below. We apologise for the delays and appreciate the continued business, recognising in the same breath the past business. And when one goes, so that's all on the 8th, when one sees the table I already showed you, you can see that that's on that date, the 8th of September, the first of the 3 tranches of monies that go towards the 8th contract goes across, following all the representations we see there. It's at page 232 of the core bundle. And again, another clear documented instance of the payment representation by Mr. Mervyn. We will deliver the trade of $10 million US to multi-choice on the 17th of September. Page 384. If we go to 386, actually 385, just while we're passing it, you can see Mr. Mervyn then writes, pushing back the trading time period, and he says this date reasonably factors in the time to trade the funds. Again, Mr. Eisenberg's in on it, Mr. Green's in on it. And everyone's sanctioning Mr. Mervyn holding himself out as trading Naira for dollars. .385 is to much the same effect. 388. 6th of October now. By this point, the 10th contract is founded, and Mr. Giwa writing to Mr. Eisenberg, following your email, payment was made to JNFX for the multi-choice trade. We know, we see it at 232 of the core bundle, that the payment was indeed made to Mr. Mervyn's company, Frontier Financial Technologies Limited. And Mr. Eisenberg doesn't say, well, no, that's not payment that's been made to anyone on behalf of JNFX. And just for your lordship's information, at the summary judgment application hearing, you don't have it in your bundles now, the court had before it, and JNFX had available to it to scrutinise, all of the statements evidencing the initial payments from MultiChoice to Mr. Giwa's company, all of the statements evidencing the payments from Mr. Giwa's company to Frontier Financial and or ChamSwitch, and all of the payments into the MultiChoice Standard Chartered bank account, which Mr. Giwa said were received for or on behalf of JNFX. So they had everything there to scrutinise, and the judge had it all there to see. And we see at 389 and 390 telexes or wire confirmations, and if you look at 389, it purports to come from a JNFX Ltd bank account into the MultiChoice Africa Limited account that started Standard Chartered at Basinghall Avenue. One for 10.87 million, one over the page for 630,000. And the explanation for this is at 388. Mr. Giwa was saying, I'd received the attached documentation from Ash stating that the transfer had been concluded, only to find out later that the documents were fake. And this is the extraordinary situation that the judge below faced. There's no dispute on JNFX's part but that these payments had never been made. Yet they couldn't bring themselves to admit what we pleaded, namely that multiple fake payment confirmations were made, and they required us to prove it. And it's just not tenable to take that position, and the judge was well aware of that. But if one looks back in the pleading, and Lordship spent a little time earlier looking at the pleas at page 210 of the core bundle, the bottom there, we said that on numerous occasions fake confirmations of sums paid over to the MultiChoice Standard Chartered account were made, and we included one for the 7th of January 2022. And they knew that no such payment had been made because they're in control of their own bank account. And it went a bit further because in the narrative...
That can't be the one we've just been looking at.
No, it's a different one. It's another one, yet another one.
Right.
And...
Yeah, but the one we've just been looking at doesn't seem to be amongst those that are specifically referred to.
It's not. I don't say it is.
Right.
But that's not an exhaustive list that you see at 41.8.
No, I see it says the word include.
Yeah. But just bear with me 1 second, just round off on this point. Yeah, you've been taken to Mr. Giwa's narrative, and just briefly to round off on this particular issue, if you look at page 202, it's actually the first of the supplementary bundles. It's under tab 6A. Sorry, 202. You can see Mr. Giwa, at paragraph 26, exhibited all of the various payment confirmations, which he said were effectively fake. And you can see they numbered 368 to 416. So they had it all, and they had the means of working out from their own banking records whether or not what Mr. Giwa was saying was true, and instead they just bleated, "Oh, you're required to prove it." It really wasn't good enough, and it still isn't. It feeds on to one of the questions your lordship was asking my learned friends about. And coming back to the documentary chronological run, we get to tab 8W, oh sorry, 8W, page 391, 13th of October, 10th contract has failed. Mr. Green, Mr. Eisenberg are in on it. Mr. Mervyn writes saying, "I've discussed this internally, and we will meet this payment of $11.5 million on or before this coming Monday." And they then have the call referred to, and the upshot is at 392. Mr. Green sends this commitment letter you see over the page at 393. It's short, your lordships, I'll ask you to read it briefly. So there we can see they accepted. There was $15 million outstanding. 11.5 was going to be paid by the 20th of October, 3.5 on the 27th of October. Recognised the payment was overdue, etc. It's sent by Mr. Green in a document with JNFX letterhead. Mr. Mervyn signing, no less. And Mr. Green expressly indicating he expects Mr. Mervyn to sign. It's possible that the one that was attached didn't have Mr. Mervyn's signature at that point. And Mr. Green giving his stamp of approval for Mr. Mervyn to hold himself out like that to the whole world. And at 4:03, or actually 394, a little bit later on, Mr. Green, in like terms to Mr. Eisenberg talking about the continued business, says at the top there, "It's very important for me to complete our commitment so we can start to repair our business relationship." Yet you've seen their whole case in Mr. Giwa's claim is they had no relationship whatsoever with him or multi-choice. And if one looks back in Supplementary Bundle Volume 1, tab 6D, this is Mr. Green giving a statement in the context of this summary judgment application, page 297, paragraph 6, final sentence, neither Mr. Giwa or MultiChoice were clients of JNFX. Well, what business relationship is he talking about then? And finally, or nearly finally in the chronological run, if we go back to volume 2 and go to page 405 now, it's a nice bookend to the November 2020 communication. On the 3rd of November 2021, Mr. Giwa writes to everybody, saying, you and your company JNFX have taken Naira payments for over 6 weeks from me for transfers to MultiChoice and Delphinus. And every day it's a different excuse. Jonathan signed a letter, etc. So again, there is no contest that Mr. Giwa's assertions here from many of these directors.
Responsibility of the shareholders and directors of the company.
Indeed. They don't say, hang on, we only do the dollar side. The reason they don't say that is because they knew at the time that that would have been a completely untenable position to adopt. They somehow think they can adopt it in court documents and no one will notice. And we turn, with that background, to a bit of a compare and contrast evidence exercise with what further things were said on the summary judgment application. It's back to volume 1 of the supplementary bundle, tab 6C. Mr. Elam's first witness statement, served in opposition to the summary judgment application, and with the context that your lordships have already got, that pretty much everything I've just taken you through, they've had since October 2022. 274, the end of paragraph 11.2. Mr. Giwa and or MultiChoice were not JNFX's counterparty in any transactions, nor were they customers of JNFX. 11.3, we've seen that. Over the page, 276, paragraph 15. There was no relationship, this is the second sentence in. Explain Mr. Mervin's not going to chip in with anything useful to these proceedings. But in the second sentence they explain there's no relationship between Mr. Giwa and JNFX. He wasn't a client of JNFX. Transactions were between Mr. Giwa and Mr. Mervin. It's fairly astounding, given the evidence that I've taken you through, that this found its way into the solicitor's witness statement. We move on. Paragraph 23.4. 279. Far from clear or established that the multi-choice contracts were entered into in the manner explained by Mr. Giwa. This is about 5 lines up from the bottom. It's a matter of fact with which JNFX via its directors and not via Mr. Mervin had no involvement at the time. It's just wrong, as you've seen. Of course, this is what the judge was being taken through as well. And paragraph 24, over the page, at 28, it ends, upon receipt of disclosure, JNFX may be able to assert a positive case as to how Mr. Mervin held himself out. I mean, it really does beg a belief, the rhetoric in this statement.
Yeah, all right. Well, I think we've got that.
Well, it goes on. 28.1. Mr. Giwa did not instruct JNFX to exchange Naira into US dollars or otherwise. Required them to prove it. That's 28.3. And possibly the high or low point, depending on which way you're looking at it, is at 30.6. which bears reading, because there the contention is made that Mr. Mervyn should have made inquiries of the Mr. Giwa should have made inquiries of the directors as to the scope of Mr. Mervyn's authority. But we've just seen he'd substantively done that for a long period of time, and they'd repeatedly confirmed that authority. And so the most generous interpretation of this statement is that the documents that I've taken you through simply haven't been read. But I'm happy to say, I'll say no more than that. But it's deeply unimpressive given the chronology that I've already taken your lordships through. Got all the documents in October 2022. The application's filed September 23. 2 months to serve this evidence, and you got a hearing 4 months later. And there's no correction to any of this. But worse is what Mr. Green said when he gave evidence on the application to set aside a statutory demand, and that's in the second supplementary bundle, tab 8II, page 565. It's served in the 9th of February 2022, so very shortly after some of the communications we were looking at. And you see at 565, paragraph 19. At the bottom, sometime after the alleged transaction, I learned of the events I described above, and in particular that Mr. Mervyn had been getting counterparties he was working with, including the parties, Mr. Giwa effectively, to send money into bank accounts in his name or in the names of entities owned or controlled by him, giving the false impression they were transacting with JNFX and would receive US dollars in exchange. I'm sorry, there is no generous explanation that can be given to that paragraph at all.
Very good. Is that a convenient moment?
That would be, my lord.
And how are you doing time-wise overall?
So I'm going to move on now to the grounds themselves, and I'm quietly confident that I'm on track, subject to that always being famous last words.
All right, very good. We'll resume at 10:30 tomorrow.